Hi everyone, welcome to our webinar today on legal essentials for online and e-commerce businesses. My name is Olivia O'Rourke and I'm a Senior Associate in our Commercial and Privacy team here at LegalVision. Before we begin, a couple of quick housekeeping items. So firstly, you will receive a recording of today's session and the slides in your email. You can submit questions as we go today in the Q&A box, and we'll aim to answer those at the end of today's presentation. And we'd really appreciate it if at the end of today's session, you could please complete a very short feedback survey after the webinar to help us improve our sessions moving forward. So by viewing this webinar today, you'll be eligible to receive a complimentary consultation with our LegalVision team to discuss how we can help your business. So to claim your complimentary consultation, you can leave your contact details in the survey or contact us via our website, and we'll be able to have a chat to you about your specific business. Okay, so today we're going to be, well, firstly, we'll get started with a bit of a quick poll. So let me double check. Yes, so we're going to start with a quick poll. I'd love to hear a little bit from you about sort of what you're interested in learning about today. So firstly, it's to make sure your website is compliant with data protection and cookies laws, having clear and enforceable customer terms, understanding your consumer law obligations, knowing how you can legally advertise and promote your business online, all of the above, or you're not sure, you're just here to learn. So I'd love to hear a little bit about sort of what you're interested in learning about today. Give you a couple of seconds just to pop an answer in. Perfect. So the answer will come up very shortly. Today we'll be discussing a few different things today. So we're looking firstly at having robust customer terms and conditions, complying with consumer law, GDPR, obviously GDPR compliance is super important for online businesses, and then marketing lawfully to customers. And then we'll end today with a Q&A. So I think the answers, it looks like, you know, you're keen to learn about all of the topics that we've got going today, which is great. That seems to be the overwhelming answer. So we'll hopefully aim to address all of those topics for you on today's session. Perfect, so let's get started. The first topic that I'd like to talk about today is having robust customer terms and conditions. So without comprehensive terms and conditions, online and e-commerce businesses can face significant risks. Unclear or not even having T's and C's can create confusion about the commercial relationship with customers, leading to disputes around critical issues for a business like payment terms, delivery obligations, refund policies, termination rights. These are some of the key issues that we see here at LegalVision in our disputes team. So it can cause really costly disputes that really could have been prevented. A common mistake that businesses make, some businesses, is copying terms and conditions from a competitor's website. Well, there's a few reasons that this is quite problematic. The firstly is, you know, it could be incorrect. The second one is that you could be infringing their intellectual property rights by copying their intellectual property. And the third thing is that your business operates very differently, or maybe even slightly differently from your competitor. And so it's really important that you don't miss any critical terms that relate to your business. Although every business operates slightly differently, we'll talk through the key areas that you should cover in your customer terms and conditions. So the first one is payment terms. Now, for SaaS and subscription services, you should specify billing frequency, for example, whether that's monthly, quarterly, annual payment, and whether payment is in advance or in arrears, and how fees are calculated. So, you know, often for a subscription service, it could be per user or feature tier, or it could be usage based as well. So really clear terms on how that payment is calculated. Fee for e-commerce websites detail when payment is taken. For example, Is it on order, dispatch, or delivery? What payment methods you accept, and any additional charges such as shipping, handling, or customs fees. For membership and content-based platforms, what you want to do is explain what each membership tier includes, if you have different tiers as well, and how people can upgrade or downgrade, the payment timing, and any promotional pricing terms. For all businesses, super important that you set out what your refund and cancellation policies are. So you should clearly state your refund policy, including any time limits, the conditions for refunds, and any cancellation fees that might apply for early termination. Remember that UK consumer law provides additional protections for consumer clients, including statutory cancellation rights, which we will talk about in more detail shortly. And then lastly, you want to include provision for what happens if late payment occurs. So, for example, you would want to include interest payment on late payment and collection costs, which is particularly important for business-to-business transactions. But also you want to include, what would happen if they don't pay within a certain time frame, such as the suspension or cancellation of services. Intellectual property. So it's really important that you stipulate what you will retain or what intellectual property you will own in your website content, your software designs, trademarks, and any proprietary technology. Now, this will apply for all business regardless of what type of business you operate. If you operate a website that allows users to upload content, you should specify what rights that they grant you in the content that they're uploading, and require that they don't upload content that infringes the rights of third parties. So particularly important if you've got any sort of user interaction or user-based content element to your website. And then lastly, you want to grant a limited license to users, which is particularly important for a software business, but also important, for other types of subscription-based businesses. So you want to grant a personal, non-transferable license to use your intellectual property and your services. And you want to explicitly prohibit copying, reproducing, distributing, or creating any derivative works from your intellectual property. Liability is a big one that you want to include in your terms and conditions. Now, you cannot exclude liability for death or personal injury caused by negligence, fraud, or fraudulent misrepresentation under UK law, but you can limit your liability for other losses if the limitations are reasonable and are prominently displayed in your terms and conditions. Really big one is to have a liability cap. So you'll want to make sure that your liability is contractually limited. So the amount that you could potentially need to pay out to the customer is limited to a specific monetary cap. And that's usually the fees paid by the customer. You want to exclude any indirect or consequential losses. So those are losses which are not directly caused by your product or your good or service if something goes wrong. So for example, if a customer loses profits or they've got business interruption or loss of data as a result of a failure in your product or service, you want to make sure that that's excluded to the extent that you can under law. And then for consumers, it's really important to note that there are a number of statutory consumer rights under the Consumer Rights Act and other relevant legislation that you cannot exclude, and that will be carved out from your liability in certain circumstances, particularly where you have consumers as customers. So termination rights, we'll talk briefly about termination rights for online services, and then we'll talk about refunds and returns, which is more specific for goods. So firstly, for customer termination rights, you want to specify how customers can terminate their account or subscription, including notice periods, cancellation methods, and the effective date of termination. So if they terminate today, when does that termination then take effect? So you need to ensure compliance with statutory cancellation rights for consumer contracts. You need to include what additional termination rights you might have as well. So include your right to terminate or suspend accounts for a customer's breach of terms, if they're not paying you, if you've noticed fraudulent or unusual activity or service abuse. So you want those additional rights. And then you want to set out what happens on termination, so the effect of termination. State what happens, so what their access is like during notice periods, data deletion timelines, outstanding payment obligations, survival of key clauses, and refund policies for different termination scenarios as well. If you've got a product or service which auto renews, you should explain what those auto renewal terms are, the cancellation procedures, and any cooling off periods, which we'll talk about shortly as well. For goods, what you want to talk about is your return process. So detail how customers can initiate returns, where goods should be sent, who bears the return shipping costs, if any, and the required condition of returned items. So you always want to specify timeframes for your customers to return goods. Include your right to refuse return of goods where there's excluded items, such as personalized goods. You know, your right to charge a restocking fee if it's legally permitted, and we'll talk about that in more detail as well. And your right to deduct reasonable costs for diminished value if the goods have been handled beyond what was necessary for the customer to try out the good. So for damaged or faulty goods, separate provisions for statutory rights apply under the Consumer Rights Act. So if a good is faulty, a consumer has certain rights. Now, including they've got 30-day rejection rights for faulty goods and repair or replacement rights, as well as a final right to a price reduction independent of your standard return policies outside of any sort of termination for convenience periods you might have. So that leads us nicely into the next topic we'll cover, which is complying with consumer law. Now, this won't apply to every business if you are, for example, offering your goods or services just to businesses. However, it will apply to a large amount of online businesses. So the Consumer Rights Act provides the primary framework for consumer protection in the UK. So for e-commerce businesses, this means you must ensure that your goods are of satisfactory quality, fit for purpose, and as described. Consumers have the right to reject goods within 30 days for a full refund if they don't meet these standards, followed by the right to repair or replacement, and ultimately a partial refund if the issues persist. For digital content and services, you must ensure that your services conform to the contract, are of satisfactory quality and fit for purpose. And consumers have the right to repair or price reduction if digital content is faulty. Now, we're going to talk a little bit about the distance selling regulations, which is the mandatory consumer protections around cooling off. So firstly, let's talk about goods. There's a 14-day cancellation right for goods. So consumers have an automatic right to cancel orders within 14 days of receiving the goods without giving you a reason. So this cooling off period begins the day after delivery. You must clearly inform customers of their right to return for free sort of before they purchase, and you need to provide a standard cancellation form which is prescribed under the legislation, which you should include in your terms and conditions, but they're not obliged to use that. So you can, for example, implement a returns portal or something like that. There are exceptions to cancellation rights. So certain goods are exempt from this 14-day right of return, which includes things like personalized or clearly custom-made items, perishable goods such as some food items, digital downloads once the downloading has begun with the consumer's consent, sealed audio or video recordings or software if they have been unsealed, and goods that deteriorate rapidly. So again, we're usually thinking things like food items. Now for service contracts, if you're running a service-based business, the 14-day cancellation period runs from when the contract is concluded. So if a consumer expressly requests, however, that the services begin during the cancellation period, so for example, they've purchased a subscription for a software product and they want to log in, and you have informed them that they will lose their cancellation right at that point in time, they will lose their right to cancel once the service is fully performed, although they may be liable to pay for services provided up to the cancellation point. Now, you need to provide certain information pre-contract, so at the point of the customer signing up. Before consumers place orders for goods or services, you need to provide specific information to them. So that includes the main characteristics of goods or services, your identity and geographical address, the total price, payment, delivery, and performance arrangements, the existence and conditions of after-sales services, if applicable, the duration of the contract and termination conditions, and if it's a piece of digital content, such as a downloadable file, you need to set out the functionality and compatibility requirements for that digital content. This information must be clear, comprehensible, and provided in a way that consumers can store and reproduce. So give them a copy of the T's and C's or a clear link to where they can find them. Now, refund processing requirements. When consumers exercise their cancellation rights, you must refund all payments received, including standard delivery costs. You need to process that refund within 14 days of receiving the cancellation notice from the consumer. Use the same payment method that the consumer used unless they expressly agree otherwise. You can't charge fees for a refund within that 14-day consumer cancellation right period. However, for goods, you can withhold refunds until you receive the goods back or the consumer provides evidence of them returning it to you, and they need to return the goods to you within 14 days of giving that cancellation notice, and bear the direct cost of return unless you've agreed that you would pay for the cost of return, such as a free return option that you've advertised. Now, there are some important changes to be aware of taking into effect in 2026 under the Digital Markets Competition and Consumers Act, which will strengthen consumer protections for subscription services. So take this into account if you're offering a SaaS product or a subscription product to consumers. Consumers will have a 14-day window to cancel after any automatic subscription renewals. So let's just say you offer 12-month contracts. You will need to, once it renews after the next year, they will again have a 14-day cancellation right once that contract renews. You need to give them clear notification before any automatic renewal, which gives them enough time to cancel before that takes into effect. And so there's enhanced transparency basically around subscription terms and renewal dates moving forward. As a result of these changes and result of the DMCC Act, there is actually some more penalties that have come into effect for breach of consumer law, which really means that it needs to be at the forefront of your mind if you run a consumer business. Significant financial penalties from the Competition and Markets Authority, the CMA, can be now enforced against businesses without going to court. And the fines can be significant. So they can be the higher of 10% of global annual turnover or £300,000 for consumer protection violations. There's also potential for criminal charges to be brought against directors as well. And of course, there's reputational damage and loss of consumer trust as the findings of the CMA are published online. As well as a potential for individual compensation claims from affected customers. So definitely some serious repercussions for businesses to be aware of. Okay, so turning now to GDPR compliance. Now, in the UK, of course, businesses are required to comply with the Data Protection Act, which incorporates the UK GDPR. So if you collect personal data as a business, it's required that you have a privacy policy in place. Now, this is an obligatory requirement for all businesses which are collecting personal data. The GDPR sets out what needs to be in your privacy policy. So some things that need to be included are things like the type of personal data you collect, what you use that information for, who you might share it with, and the details of an individual's rights under the UK GDPR. Your business's privacy policy needs to be freely and easily available, such as on a page on your website. And you should also provide this to individuals when you collect their personal data. So for example, if you've got a contact us form, you should let individuals know before they submit that information that you handle their personal data in accordance with your privacy policy, and ideally provide a link to that privacy policy there as well. It's very much a living document. It needs to be updated every time you change how you're dealing with personal data in your business. Next, we're going to touch on cookies. So cookies are, when you use them on your website, you must tell individuals that you use cookies, explain what they're doing and why, and get an individual's consent to store a non-essential cookie on their device. So most businesses will use cookies in their website. If you're not sure, you should talk to your website developer or tech person within your business. So the consent element of this can be achieved by using a cookie pop-up, which I'm sure you've seen on many websites when you go onto it. So as part of your cookie pop-up, what you should provide is detailed information about the cookies you're using, why you're using them, and provide a link to your cookie policy or information about your cookies within that cookie pop-up or banner. So yeah, make sure you're getting consent every time before you're placing cookies on any user's device. Data processing agreements. So there's two kind of circumstances where you might need a data processing agreement. For example, if you are using, as many businesses do, a third party to help process your client personal data. For example, you might have a CRM, you might have an external email marketing provider. In all of those cases, the GDPR states that you must have a data processing agreement with the supplier that you're using. Now, most large suppliers, providers like HubSpot will have these available on their website as part of your customer contracting process. However, you need to check that for smaller providers, you might be required to provide them with this agreement, such as maybe smaller businesses that are supporting you and maybe are not based in the UK or perhaps are not aware of their GDPR obligations. In addition, so if you're a technology company, such as a B2B subscription provider, so for example, you have business clients and you're processing, let's just say, their customers' data or their employee data, then you're very likely to require a data processing agreement to be put in place as well. So in that circumstance, it's best for you to put forward your data processing agreement as part of your contracting terms and conditions. All the information that's required to be in the data processing agreement is set out in the GDPR and should include items such as what information is being processed, for how long, and what can be done with the personal data that's being processed. And we'll talk a little bit more about data processing agreements when we're talking about sort of transfers of personal data to third parties. Now, there's some other documents that you need to be aware of. Firstly, a data protection impact assessment. Now, that's an internal document that you need to prepare when you're doing particular processing of personal data that is likely to result in a high risk to individuals' rights and freedoms, particularly if you're implementing new technologies or you're doing large-scale processing of sensitive data, for example, health data. Now, the ICO provided a useful template for this, and the purpose of it is to really assess the effect of the data processing that you're going to be undertaking. A transfer risk assessment is a tool that is required to be done when you're transferring personal data to a third party outside of the UK or the EU or another jurisdiction which is not deemed adequate by the ICO, which is the privacy regulator here in the UK. Now, for example, a business based in the US that's not signed up to the US UK data bridge is going to be a business that is deemed sort of to provide sort of inadequate protection for personal data. And so you'll need to put in place extra clauses into your data processing agreement with that third party, as well as prepare a transfer risk assessment before you transfer personal data to that third party. Now, the ICO also provide a useful template for this type of risk assessment. You should also consider some internal policies, such as a data retention policy. So how long will you retain each type of personal data that you're collecting? A data breach response plan. So how will you respond if there's a suspected data breach within your business? And this should set out a step-by-step guide for your employees and internal sort of directors. And any other sort of internal policies that you might need to help manage the personal data that you're collecting. So, for example, if you've got a customer service team that deal with phone calls or dealing with customer interaction, sort of what do they need to do if they receive any sort of request for deletion of personal data, access to personal data, and dealing with sort of third parties requesting another individual's personal data as well. So just consider the type of business and personal data you're collecting, and then sort of make sure that you've got really appropriate internal policies to manage that. Now, the last topic that we're going to cover this morning is marketing. So obviously super important for businesses to market to their consumers. Now, email marketing is obviously a big way that businesses will do this. For email marketing, the laws that govern sort of how you can market to your consumers by email are firstly the UK GDPR, but also primarily the Privacy and Electronic Communications Regulations, the PECR. So firstly, in terms of GDPR, you need to have a lawful basis to process personal data for marketing purposes. So you might rely on the lawful basis of consent or potentially legitimate interests. If you've not got consent from the individual, but you do have a legitimate interest to market to them. But that should be assessed on a case-by-case basis. Now, under the PECR, there are consent requirements. So for direct email marketing to individuals, so consumers, you will need explicit consent unless there's an existing customer relationship. So you can't just sort of email market to a generic customer list that you've been provided if they've never been a customer before and you've never received consent from them to email marketing communications to them. Now, consent needs to be freely given, specific, informed, and unambiguous. So you can't pre-tick a checkbox and sort of presume that that gives you the consent that you need, because that will not be valid consent. However, of course, there is a soft opt-in consent option, which is for existing customers. So let's just say that a customer, you run a sort of e-commerce business, a customer has purchased a good from you. You may not have got explicit a tick box consent when the individual is making that purchase to send them further marketing. However, if you're email marketing to them similar goods or services that they purchased from you in the first instance, you can send them email communications as long as you give them an opt-out. So every marketing email needs to include a clear, easy way for the consumer to unsubscribe. You need to process those unsubscribe requests promptly, usually within 48 hours, and you can't charge fees for them to opt out of the marketing consent. You need to keep records of your consent and opt-outs to demonstrate compliance. Now, there's different rules that apply for a business email address. So you can generally email corporate email addresses without prior consent, but you should still provide them with opt-out mechanisms and respect any requests to stop marketing to them in the future. Now, social media and digital marketing and influencer marketing. So it's obviously a huge way for businesses to, get more reach out to potential buyers of their products or services. So under the Digital Markets Competition and Consumers Act, the DMCC Act that we talked about before, it's unlawful to use editorial content in media to promote products when you've paid for the promotion without making this clear to the audience. So all sponsored content must be obviously identifiable as advertising. So if you've paid an influencer or provided them with perks and promos in order to, get the content from them, that needs to be really clear. So when working with influencers, ensure that they use clear labels like ad, hashtag sponsored, or hashtag gifted, and that needs to be prominent. The CAP code considers content and marketing communication where influencers receive any payment. So this could be cash, it could be free items, affiliate payments, or they've had a commercial relationship with you in the last 12 months. All of those are sponsored sort of communications for the purposes of making sure that you make that clear to the broader audience. Now, as a business, you will always remain liable for the content posted by the influencers you engage. So it's super important that you use, you can't use influencer partnerships as a workaround for complying with advertising laws. You should make sure that the influencers are only making sort of warranties and claims about your products that you could clearly make yourself. So make sure you've got a really good contract in place with those influencers setting out those obligations. Now, remember that social media platforms like Instagram and TikTok have also got their own terms and conditions that you need to comply with. So in addition to those legal requirements as well. So just make sure you're following the T's and C's of the platform that you're using. Perfect. We've briefly talked about cookies, but just to kind of reiterate, this is obviously a really important tool that's used by businesses. And it usually kind of when you're using cookies alongside social media, it will usually involve tracking online behavior so that you can sort of provide targeted advertising and retargeting ads to an individual's social media account, and perhaps also location-based promotions as well. So you might choose to target social media accounts which are in the vicinity of your business. So you need to obviously get that consent in order to use cookies, and make sure that you're using a cookie consent provider to collect that. Just make sure you're not using non-essential cookies before you receive that consent through the cookie banner. And as we said around sort of the consent for email marketing with cookies and your cookie banner, pre-ticked boxes for cookie consent are not legally valid consent for cookies either. So make sure you do not have any pre-ticked boxes in your cookie consent banner. And just sort of general marketing compliance, just to sort of reiterate on this. So truthfulness and evidence, I guess, always make sure that your marketing claims are truthful, accurate, and you have evidence to back up any statements about product efficacy. This applies across all marketing channels, emails, social media, and digital advertising. The DMCC Act prohibits unfair commercial practices that would likely cause consumers to make a transactional decision they wouldn't have otherwise made. So don't create any false urgency, make any sort of misleading price claims or describe services as free if they've got hidden costs. Now, record keeping, always maintain comprehensive records of your consent, your marketing agreements, influencer contracts, and your compliance efforts. So these records are really essential for demonstrating compliance to the regulator if you were ever to receive complaints against you. And obviously contractually, it can help you if any disputes were to arise. Always also be aware of any industry specific rules. So for example, additional regulations may apply if you operate in sectors like financial services, gambling, alcohol, pharmaceuticals, or food and nutrition, beauty products as well. I mean, there's loads of different industries where they might have specific marketing restrictions which apply across all marketing channels. So just make sure you get the right advice for the product that you're offering. Okay, definitely a lot to unpack there. Firstly, just wanted to say that concludes the main part of our webinar. You might find this publication useful that we have here. So you can, if you're a member with us, you can find that in the resources tab, or you can scan the QR code below to download a copy of our How to Start an Online Business in the UK. And I just want to sort of flag, we have these webinars all the time, typically every week or every second week. So the next webinar that we have is Protecting Your Brand from Idea to Commercialization, which is a fantastic intellectual property webinar that we'll be covering, which is next Tuesday, the 12th of August. And you can register by going to legalvision.co.uk/events. Now, I'm going to answer your questions shortly. Just to give you a little moment to submit any final questions, I'm just going to briefly talk to you about LegalVision's membership. So firstly, just to address, so by becoming a LegalVision member, your business gets unlimited access to our full team of specialist lawyers for your business as usual legal needs. So it's like having your own in-house counsel for the fraction of the cost. Our team can assist you with unlimited document drafting and review of contracts, unlimited legal advice consultations, and unlimited trademark registration, and much more. So as a LegalVision member, you won't worry about the cost of lawyers ever again. It's a fixed monthly fee. Think about it as having your own in-house counsel, and we'll take care of all your business as usual legal work, so you can focus more time on running your business. If you are an in-house counsel listening to this webinar, we also offer a dedicated service for in-house counsel to manage your high volume business as usual legal needs as well. To learn more about how our membership or desk extension options can help you, please request a free consultation when the survey appears at the end of the webinar, so the team can provide you with more information. Fantastic. So we're just going to answer some of your questions with the time that we have left. There was a pre-submitted question that I'll answer briefly, which was legal essentials for online businesses importing goods from abroad. So I guess the first thing to address there is obviously, aside from everything else we've touched on today, which is obviously totally relevant for a business that is importing goods from abroad and then selling them here in the UK. Some additional things to consider would be registering for an economic operator registration and identification, which is an EORI number. Make sure you've got that in place. Now, check if the goods you are purchasing require import licenses or permits to sell, and if there's any sort of regulatory requirements around the goods that you're selling, such as ingredients and things like that here in the UK. And we recommend to our clients that you engage with a customs agent to support you with customs clearances. They can support you with various sort of tax codes and obviously the customs element of importing goods from abroad. Similarly, also speak to an accountant, which will help you to deal with VAT and input tax. So they'll be sort of best placed to advise around the tax element as well. But yeah, you obviously need to make sure that your product meets UK safety standards, and that you have a contract in place with your suppliers. So if something goes wrong, you obviously have potentially, if you're supplying goods to consumers here in the UK, you'll always have obligations to give them a remedy under consumer law. And if those goods have been imported from a business abroad, you want to make sure that you can pass through any sort of remedy that you might need to give the consumer, such as a refund. Or a repair, for example. So obviously just make sure you have those rights against the supplier that supplied those goods to you as well. Super important that that's dealt with contractually. Those are probably the key things to sort of deal with if you're a business, selling goods imported from abroad. So I think we have a question here, there's a free consulting provided. You have two limited companies, one is consulting and another is a finance and accounts company, and you want to set up an e-commerce website for selling services through the website. So yeah, you can absolutely sell services, I guess, through your website. Now, I suppose, it sounds like your consulting and finance and accounts company, you're providing a service. Now, I'm not sure if you're providing services to consumers or to businesses. If you are providing services to consumers, then you do need to be aware of their 14-day cooling off right. And typically they have a right to cancel the services within the 14 days, although they do need to pay for the services that they have been provided during that 14-day cooling off period in that time. So yeah, just be aware of that if you are providing services to consumers. In a business-to-business scenario, it's just sort of whatever you agree by contractors, the minimum contractual term and things like that. So I hope that answered your question. We've probably got time for one more. We also have another question here. So what's the difference between termination rights that we should include for business to business versus business to consumer customers? Can we have different T's and C's for different customer types? The answer is yes, absolutely. You can split those out into two different contracts if that's an easier way of kind of dealing with your consumers and sort of your contractual needs. However, you could join them together in one terms and conditions if that's how you offer your products, and then you can essentially just sort of include different termination rights. So for example, a certain clause will apply if they're a consumer, and certain clause will apply if they're a business. Yeah, as I sort of briefly mentioned in that last response, so business to business termination rights, typically kind of whatever's agreed under the contract. Whereas for B2C, it is also kind of what's agreed under contract. However, you have to take into account the consumer law cooling off rights. So based on the type of goods or services that you're offering, potentially cooling off rights will apply, which gives them the ability to cancel the contract within 14 days. But again, it will depend on the type of good or service that you're offering. Hopefully that answers those questions. Please do let us know if you have any additional questions that you would like us to answer. Of course, if you would like us to chat about the membership options we have available, we can discuss more in those consultations, those free consultations that you can request. But yeah, look, that's all the time that we have for today. So as I said, the survey will pop up at the end of today's webinar. We'd be super grateful if you could complete the survey at the end of the webinar. And to claim your complimentary consultation, you can leave your contact details in the survey or via our website. So yeah, while this is a free webinar, we obviously value your feedback. So please do complete the survey at the end of the webinar. And thank you so much for joining us.